be pre-printed, your lordships. So the top right hand side will be pre-printed having the candidate details. But at the left hand side on top, my lords will find a vertical barcode. This part on top. Now this remains constant. So my lord, after my lord, the your lordships have already been apprised about my lord, the allotment of candidates to different examination centers. First PWD, women. Thereafter, my lord, candidates are allotted to all the examination centers. But once the candidates are allotted to the examination center, my lord, the hall tickets will be pre-printed. Now these are given to the candidate at the time of writing the examinations. But after all the examinations are completed, my lord, this top right hand portion, my lord, will be the perforated sheet will be taken off. Now this means, my lord, that without the top right hand portion, no one will know as to whose answer sheet this is. Eventually, my lord, it will have to be corresponded only with the barcode number. So, my lord, it will become an anonymous randomized sheet where, my lord, no one would know whose answer sheet belongs to whom. These are then bundled, my lord, into 40 each by mixing up all the answer sheets so that, my lord, it remains complete anonymous. And, my lord, then they are sent to different invigilators, my lord, examiners for the purpose of marking. So, my lord, in the first round, your lordships, my lord, I think have already been apprised. My lord, in the middle part becomes, my lord, the first sheet that is filled up by the examiner. And your lordships would see, my lord, in that left hand side box in the middle portion, your lordships will see the valuer's ID, which is mentioned. The valuer signs. My lord, CE is, my lord, the chief examiner. So there is someone who is supervising. He signs. My lord, in the middle of that, my lord, portion, which is the second perforated sheet, your lordships will also find the signature of the scrutinizer. My lord, once this is done, to ensure that there is no arbitrariness in terms of marking, my lord, the hawk and dove syndrome that the Honorable Supreme Court referred, my lord, the mark, my lord, I'm sorry, the answer sheet, my lord, the second part is then torn off. The second part is kept with the Public Service Commission. My lord, the answer sheet is sent for the second evaluation to the second evaluator. So, my lord, the answer sheet goes without details of the candidate on top, without details of the marking, my lord, that was done by the first examiner. My lord, the second sheet is the last sheet on the page is used, my lord, by the second examiner. My lord, once, my lord, it is found that if there is a variation of more than 15% between the first examiner and third examiner, my lord, then this bottom sheet is also removed. My lord, third page of this sheet, your lordships would see, there is the third evaluation to be done by the third evaluator only for such of those cases, my lord, where there is more than 15% variation. Third sheet, your lordships. My lord, the argument with regard to bubbling not being there, my lord, was already argued by Mr. Prakash Reddy. This is what, my lord, the commission had specifically argued. These are only for those stray cases, very limited cases where there is a variation. Actual numbers were also supplied. My lord, they were, if I remember, 3.76%, my lord, of all the marks that were examined resulted in a variation of more than 15%. One other argument that was made before the learned single judge was, if all the three perforated sheets on top are torn off, there is nothing that will show as to how the third evaluer's examination must be related to the candidate. My lord, this was explained by saying that even if, my lord, these three perforated sheets are torn off, the vertical barcode remains. This is constant. It remains, my lord, with the third sheet. It remains with the entire answer sheet. So this third vertical barcode will be used for identifying which of the papers that were sent to the third examiner corresponds to which candidate. So, my lord, now at this stage, till all the first two evaluators, 3.7%, my lord, where there is a variation, third evaluator, none of them have any visibility about this top sheet. Nobody knows which candidate it is, and each center, my lord, is not sent to one evaluator. All the centers' papers are mixed up, bundles of 40 are made. So, my lord, different evaluators examine students from different centers. So, it's complete uniformity. But after this entire marking process is complete, then this barcode, my lord, is related to the barcode in relation to the slip on top of the page to identify which candidate got how many marks. So my lord, this was the method that was followed in terms of conducting the evaluation. So my lord, the arguments about certain centers, my lord, having resulted in a higher percentage, my lord, in the method that was followed is not possible, and in practicality, my lord, these documents were also placed, my lord, before the learned single judge to show the pattern as to how many candidates, my lord, succeeded from each centers. This allegation was completely bereft of, my lord, any truth. But if my lords may kindly have this, in fact, my lord, was also shared with my learned friends before the learned single judge to show the percentage. My lord, this is center wise. My lord, we have shown, my lord, the highest percentage of successful candidates from a center on top, and it goes down in terms of decreasing percentage. My lord, the centers, my lord, that they say with regard to, my lord, the women candidates having succeeded in disproportionate number are centers number 18 and 19. Now, my lords would find center number 18 is at number 3 on that list. Center number 19, your lordships, is at number 13 on that list. And if my lords were to see the percentage, center 18, which is Koti Women's College, my lord, has a success percentage of 5.41, which roughly corresponds to the top 7 or 8 centers. And there are 2 centers, my lord, which got a higher, my lord, success percentage from one center. My lord, and the center number 19 has a success percentage of 4.12. There are 12 centers or 11 centers other than center 18, which had a higher success percentage. So, my lord, this contention also, my lord, in my respectful submission was completely incorrect. My lord, then one other aspect I must mention, my lord, this scaling and moderation.
Yes.
My lord, the Honorable Supreme Court in Sanjay Singh's case, my lord, uses scaling distinctively, my lord, from moderation. My lord, your lordships are aware, my lord, in the UPSC, when someone is taking the central services or for several other examinations, my lord, people can choose electives. It is not one common subject. So, my lord, suppose if I'm appearing for a UPSC exam and I choose political science, another candidate chooses mathematics, another candidate chooses economics as the major, my lord, the markings for each subject will be different. So, my lord, the Supreme Court said you must have some scaling mechanism. So, someone who gets 90 as a top mark in economics, and if someone gets 70 in political science as the top mark, then the candidate who chooses political science should not lose out, because the marking will naturally be lesser than 70. My lord, the top people in economics will all get between 70 to 90. Supreme Court suggests please do a scaling. Scaling meaning that you have some mechanism where there is an equation that happens amongst people who choose different subjects. My lord, this is how Supreme Court uses the word scaling. But I must confess, Supreme Court uses the word moderation little differently. What it means in terms of moderation is this hawk and dove syndrome. Someone could have an extra strict evaluator, someone could have a liberal evaluator. The same candidates having similar papers, someone could end up with a higher ranking, someone could end up with a lower ranking. Lordship Justice Ravindran Millard speaking in that bench said you must have a moderation mechanism which ensures that these disparities don't occur. So, my lord, in the first counter that was filed, my lord, which was read, which will be, I'm sure, my lord, again read again to your lordships, but it was shown, my lord, by my senior friend, Mr. Prakash Reddy. When Public Service Commission answered, it answered and said, because we are having only one exam, unlike UPSC, which has different examinations, there was no necessity of scaling. It used / moderation, because it used scaling and moderation for the same understanding. But my lord, that same counter affidavit, again, Mr. Prakash Reddy was at pains to point out to your lordships, mentions that we actually, in effect, used 2 invigilators. We had a third invigilator to deal with a disparity of more than 15 percentages points. So, my lord, so in effect, we also had moderation, though the counter affidavit that does not deal with that other aspect as moderation. So, my lord, the learned judge's finding that we have originally said there was no necessity of scaling or moderation is inconsistent with our argument that there was moderation actually done, though scaling was not needed. But that, my lord, I just wanted to point out for your lordship's consideration. But just only one or two more points, and I think I should conclude. The discrepancies numbers was answered by Mr. Gopal Shankar Narayan. But the number of candidates who appeared was always constant. The chart, my lord, that was placed to your lordships indicates why. In the initial on the go, your lordships are aware, not even when elections are conducted, a body as high as Election Commission of India, when it gives the numbers, these are subject to final confirmation. There was a variation of 17 only. 12,100 candidates wrote the exam. There is no change. 25 candidates, my lord, High Court directed results to be withheld. 25 candidates reserves were withheld. Another, my lord, 941 candidates did not, or 841 did not qualify in English. All those details, my lord, I actually had a separate chart, but that is covered, my lord, in the chart that was placed by Mr. Gopal Shankar Narayan. My lord, these were the figures that were given by the Public Service Commission before the learned single judge. My lord, then successive candidates, this is an argument that has not been addressed. My lord, the learned judge finds that candidates having successive roll numbers ended up having identical marks. But this was also explained to the learned single judge that one should not look at the total marks because there were 7 subjects. They had to take, my lord, tests in 7 different subjects. When you see subject by subject, there is no equal marks. But they are having a variation in each of the marks. The total may qualify. My lord, like if I give a 10th class example, my lord, history, I am getting 60. My friend sitting next to me will get 70. In mathematics, if he gets 75, I get 65. Social, not again, we get 5 marks difference. Eventually, my total will be 420 out of 600. His total will be 420 out of 600. But every individual subject, it is not equal. So, my lord, the argument that was made on the other side was that something that points to irregularity, similarity of numbers to 2 successive candidates. We explained it, but the learned single judge fails to notice it. My lord, then 16th August 24, but the other argument, my lord, that weighed with the learned single judge was we had completely new hall ticket numbers for the main examination without following the same hall ticket number which was given for the preliminary examinations. The learned judge drew a parity, my lord, with the UPSC exam in which, my lord, the same hall ticket number is continued. But we placed before the learned single judge that there is no rigid rule. My lord, for example, my lord, the junior civil services exams conducted by the Honorable High Court gives a new number for the main examination. It does not follow the preliminary hall ticket number. My lord, we gave a good reason as to why we decided to give a new number in seriatim, because in terms of this answer sheets, but everything was going to be pre-printed. And in the pre-printed hall ticket number, we wanted to start with 1, go up to 31,000, my lord, who are the qualified candidates. Otherwise, my lord, the hall ticket numbers would become random. Number 3 candidate may have qualified in the prelims. Number 7 would be the next qualified candidate. 10 would be the third candidate. 14 would be the fourth candidate. Numbers would then jump 3, 7, 10, 14. It was felt by the commission that whoever qualifies, let us give them a new hall ticket in a seriatim so that when this answer, answer sheets are printed, we can have this seriatim done in a clean way and the examination centers can be allotted in a clean manner. But largely, my lord, most of these issues your lordships have said, these are not the intricacies the High Court needs to be bothered or needs to go into. But I'm just placing, my lord, that for everything, my lord, there was a complete answer that was placed before the learned single judge. My lord, last of these points on this, my lord, preliminary and main hall ticket numbers. 16th August 24, my lord, after the prelim results came, my lord, the sample my lord, hall tickets were published for anyone to have an objection, to report an objection. My lord, no objections were received. 21st to 27th November, after 3 months, the main exams were conducted. No complaints. People were happy. They went, they saw their names were correctly printed. They saw their preliminary hall ticket related to their preliminary hall ticket number. And they saw the main hall ticket number, which is a new number related to the number given to them. They are completely happy. My lord, results were declared on 30th March 2025. First complaint about different hall tickets comes in April 2025, my lord, when the writ petition is filed. 8 months after the sample, 5 months after the exam and 1 month after the results. That there cannot be a different hall ticket number. One last topic that is left, my lord. My lord, no writ petitioner who attended the exam made a complaint that the evaluators were not properly guided by having some key answers or a ranking methodology that was told to them. In an objective question, my lord, where I am giving a 15-sentence answer, my lord, no one questioned that this methodology, there should have been a key answer. The evaluators need to be trained on the marking so that there is no large variation. First, there was a systemic safeguard built inbuilt, which is, my lord, if there's a moment there was more than 15% variation, there's a third evaluator. But even to ensure that there is no variation between one set of 3 evaluators and other set of 3 evaluators, but nobody raised a plea. But when the matters came before the court, but in the first instance, at the time of interim argument, I am told, my lord, the standing counsel, my lord, who was appearing was asked if there is an answer sheet and key answer that was provided. It was a question that fell, my lord, because it was not pleaded and instructions were not available, my lord. The standing counsel seemed to have indicated, my lord, that there is no answer key because this is objective question on a long form basis. My lord, later when the matter came for final hearing, my lord, I was instructed to assist the honorable court. So, my lord, I personally assisted the honorable court, and this is something that I can recount, my lord, because the learned judge attributes a wrong statement, and I'm sure my friends on the right side are all fair senior counsel, and they will be able to tell your lordships that I'm not telling your lordships an incorrect statement. The learned judge in the middle of my arguments asked me, is there an answer, key answer prepared? My immediate response was, I need to get instructions, I'm not sure, but to me, it appears that there is no necessity of a key answer because this is a long form answer. In a long form answer, I don't think there can be a specific detail with regard to how the key answer is to be prepared. But this is my immediate response without instructions from the client. I am taking instructions from the client and I'm reporting to your lordships later. Next morning, because I took full instructions from the client, and to my pleasant surprise, my lord, they had indicated that they had a complete key answer. Each evaluator was trained that if for this particular question, you please understand that these are the parameters on which you will give marks. So someone may write on, my lord, XYZ, another person may write on ABC. It should not be that the examiner to his subjective mind will think ABC is right and he should give some marks, and whoever writes XYZ should not get any marks. So, my lord, we then came back at page 355. Lordship just notes the page number. We filed an affidavit before the court, placing the full instructions, including the 955. I'm sorry, not 355. My apologies. 955. Additional affidavit by the commission, specifically stating the key answers that were prepared in respect of every answer, both for English and Hindi medium, English and Telugu medium, and how the evaluators were trained to follow that key answer pointers for the purpose of marking. My lord, the learned judge, my lord, at page 303, para 345, my lord, refers to this variation in the original oral instruction argued across the court and the subsequent written instructions filed into the court, and says that this variation is something that is suspicious. But this is not on the commission. This is, my lord, a question put to us across the bar by the learned judge without a single pleading by any person, on which, my lord, the commission could not have responded earlier. The first opportunity the commission had to respond was after the question was put to us by way of this additional affidavit at page 955. So, my lord, just to summarize now, because I'm already exceeding my time. Each of the evaluators, my lord, was fully trained, key pointers given. They were taken through, my lord, an exercise, mock exercises, my lord, they were made to mark on mock papers. My lord, 955 gives the full details. That was verified, my lord, by the examiners to see if, my lord, the evaluators are going awry in marking. They were then trained to correct, so that, my lord, there will be a uniformity in process. All of this happened before they actually dealt with the bundled up answer sheets given to them in an anonymous form. But fully captured, my lord, not only in the additional counter affidavit, my lord, which your lordships have been extensively taken through by the learned advocate general. 955 is an affidavit that your lordships have not been troubled with, that deals, my lord, with the preparation of all these evaluators on how they need to conduct exams. Lord, I am deeply grateful.
Yes, sir. For Mulod, almost Mulod, all the points are covered except few Mulod. In fact, Mulod, I remind Mulod again two important aspects. Mulod,
Yes.
Mulod, the history of Mulod, the Group 1 service examination in this region, Mulod, is Mulod one of the prolonged Mulod suffering and longest delays Mulod from the year 2011. The 2011 notification, which was issued, subsequently cancelled, and also, my lord, that the notification number 15 of 2011, this is the part of the pleadings, and my lord, the another one, after agonizing gap of, my lord, the 11 years, another notification for 2022, my lord, was issued, and again, my lord, it has turned into a tale of despair. Again, this was cancelled, not once, twice. My lord, after 13 years of long awaiting, my lord, for thousands of unemployees, my lord, this notification was issued. My lord, after issuance of notification, my lord, including the writ petitioners, successful candidates of 563 appeared for, my lord, appeared for prelims exam, mains examination, and GRL ranking was also published, my lord. My respectful submission is, my lord, these writ petitioners, 20 writ petitioner in one writ petition, 15 number in another writ petition. My lord, they kept, my lord, wait and see. My lord, the double hall ticketing was, my lord, issued. This was long back on 16/8/2024. My lord, they never challenged. They still waited till, my lord, the verification of certificates and written examination main. They never objected. They never made any grievance or representation before, my lord, the service commission or otherwise at least through court of law. They waited after, my lord, not being selected, my lord, 27/9/2025, after long lapse of many months, my lord, one of the, my lord, some petitioners, my lord, after announcement of general ranking list, my lord, they resigned for the jobs. Many of the candidates, my lord, in this 563, my lord, after that they filed the writ petition. My lord, I bring to lordship's kind notice, my lord, the averment of the writ petition, paragraph 3 to 35, my lord, one of the writ petition filed by senior counsel Rachna Reddy and associates, my lord, paragraph 3 to 35, the writ petition, page number 329, page number 329 of the writ appeal, my lord, 1066. My lord, the entire paragraph 3 to 33, my lord, except, my lord, the allegations of the averment of the allegations of irregularity, the double hall ticketing, the first basic one, my lord, broadly the entire, my lord, analysis of this, all the writ petitions, my lord, 7 issues were raised, the irregularities, my lord, the broadly I can say. The first one, issuing enough 2 different hall tickets, my lord, this is already, my lord, already notified, my lord, they, in the website, 2 hall tickets are being issued. One is for the prelims and mains. My lord, all have received, my lord, in pleasure. They appeared for the examination. They never objected. And my humble submission is, the issuance of double hall ticketing, the mentioning of the prelims hall ticket and also the mains, my lord, will not cause, my lord, any, my lord, prejudice, my lord, and also not any loss to these, my lord, the writ petitioner, my respectful submission, because there is no mismatching of the hall tickets, my lord, there is no any, my lord, replacement of the numbers. There are no such allegations. My lord, the numbers are generally allotted for the convenience of, my lord, the hall ticketings and also the number of candidates. The other one, my respectful submission is, my lord, the other one is allocation of examination center in a biased manner. My lord, these allegations were answered in the counters by the Telangana Public Service Commission in detail. My lord, I submitted, my lord, my written synopsis. My lord, written synopsis. My lord, I supply one more copy. Of course, Land Senior Counsel Prakash Reddy Garu has submitted, of course, the point to point. My lord, mine is a microscopic examination of the writ petition contents as well as the reply of the the Telangana Public Service Commission and the key points for the division bench appeal, my respectful submission. All these are, my lord, I need not, because it runs into 10 pages, I don't waste lordship's time. Only, my lord, everywhere, my lord, this is, the first one is issuing 2 different all tickets. The second one is, my lord's, allocation of examination centers. The main grievance, my lord, a particular, my lord, allocation of centers, it is not the, my lord, the decision of the service commission. It is the request of the women, my lord, the college, that is the Koti Women's College, and a separate allotment of centers, my lord, in no case will cause a prejudice, and in no case, my lord, my respectful submission, that is already number 2, my lord. What is the findings of the judgment, paragraph 314 to 318, and also, my lord, the Telangana Public Service Commission submissions and counters, and also key my lord, the points for consideration. My lord, I need not repeat, it is already written in a, my lord, a systematic and a chronological way. The third one, my lords, inconsistency about the total number of candidates, my respectful submission. My lord, all these allegations of paragraph, my lord, averments, paragraph 3 to 33, my lord, it's not their case that there is a, my lord, the more number of the candidates than, my lord, the list given by the Public Service Commission. And also, there is not a case of, my lord, mass copying, my respectful submission. Entire writ petition does not speak. And the other important point, there is no any impersonation. My lord, if it is also a serious irregularity, if it is there, simply they say that the numbers varied from time to time, but there is a biometric attendance, my lords. My lord, neither, my lord, the writ petitioners, even the honorable court has not done the full exercise, my respectful submission, calling for the records, what exactly the allegation and what, my lord, in case if the court is of, my lord, coming to some doubt, court is having a power under 226, no specific records of particular, these all the things were called for without their being. And the fourth one, my lords, multiple evaluations and, my lord, that is a procedure contemplated as per the Public Service Commission. And, my lord, the writ petitioner also surprisingly found a fault with the publication of the provisional list also. My lord, the publication of provisional list, which bears on the record of the answer scripts of every candidate. Basing on that, the marks are, my lord, written, my lord, on the list and supplied to the candidates. It's not case that, my lord, there is a change of marks. Of course, revaluation, that is a different, my lord, something he changed. And another, my lord, one of the averment, my lord, what I have drawn. Sixth, my lord, disclosing the unqualified candidates hall ticket numbers in the main and final mark list. My lord, even if they are not qualified, my respectful submission, if their numbers are given, in no way, my lord, it will affect, my lord, very sanctity of the validity of the examination. So my respectful submission. And other thing, my lord, these are all, and also since 2011, my lord, these are all, and here now the 563 candidates, my lord, after having resigned many of the candidates, now they are already selected, and the entire averments of the writ petition without any basis and record, just merely, my lord, assumptions and presumptions, and only their suspicion, my respectful submission, the entire affidavit nowhere enclosed any proof, my lord, in the absence of proof. And moreover, my respectful submission is, in such a, my lord, a group 1 services examination or UPSC examination, this is a matter pertaining to, my lord, the court single judge has ignored, my lord, the legal propositions. My respectful submission is, my lord, the court is not an academic and expert body, because, my lord, the entire conduct of examination from the date of issuance of notification till the, my lord, declaration of results, a procedure is contemplated. No rule of TSPSC, my lord, has been challenged by any of the writ petitioners. My lord, I don't waste the time, my lord, because all the senior counsels, my lord, AG and others, they submitted, my lord, my lord, the number of the judgments, which, my lord, clearly says all these allegations are a technical lapses, if at all, and for no fault of these 30,000 candidates. And admittedly, these were not in the merit list, and Telugu medium students were neglected. This is, my lord, no proof is filed. Simply said that, my lord, in one examination center, if the meritorious candidates are allotted more, they will be selected more candidates. It does not mean that there should be a proportional selection for every, my lord, the center, which is a, my lord, a wrong contention, my lord, unacceptable contention. And, my lord, all these things all are covered, my lord. I don't trouble lordships, my lord. This is all, my lord. The examination was in accordance with the rules. The procedure was not challenged. This is after not having selected for, after the entire process, it's a wait and see, and the entire writ petition averments are not having any evidence or a record or a proof or even a single document, just allegations, simply basing on the counter, basing on the technical sum, my lord, the lapses that will not go to the very root of the examination. My lord, this is my humble submission for the consideration.
Before my learned friend starts, or the respondent starts, there is one cross appeal, but in which I am appearing for the respondents, which are the successful candidates. The predicament is, I will have to argue after the cross appeal is argued. I'm just informing your lordships, as and when my turn comes, while I'll be arguing in favor of the successful candidates, it would have to be in response to writ appeal number 1470, which is the only cross appeal. And I may be permitted to argue after the writ appeal is argued if there is any new point made up.
He stands in the same position as the Public Service Commission or any other successful. Therefore, they have to complete their turn. Let him complete his.
No, in all fairness, what the learned senior counsel says appears to be the right position, that you argue along with the.
I will leave it to your lordships. The only thing is, if a writ appellant makes any new point, I would not have the opportunity to reply. I may be allowed to reply at that stage. Because in the writ appeal, they have taken certain grounds. Those grounds would have to be argued by the appellant, and I will have to respond to those. Those go beyond what is mentioned.
No, those grounds which are taken in the writ appeal are already in your knowledge.
Yes, they are.
So you answer them.
As your lordships please. I have the note ready also, I can answer them right now.
That is the convention.
Yes, I can give that.
Your cross appeal is in answer to which appeal?
No, it's not a cross appeal. It's a
Cross
regular
appeal.
It's a regular appeal.
Regular appeal.
It's
Writ
a
appeal is
regular
filed.
appeal. His selection is cancelled by the or set aside by the
But I'll put it this
writ
way.
court.
All the present.
Therefore, he becomes a regular opponent.
And all the appeals that were filed and were being heard.
No. I'm sorry, I misunderstood it as a cross appeal because I think it was portrayed as a cross appeal.
Yes, I said it as a cross appeal, but it's actually a writ appeal of the unsuccessful candidates filing an appeal against the learned single judge's order. That is the only writ appeal that was filed belatedly with condoned delay. Delay has been condoned, it would have to be heard. But it will be a direct appeal by the unsuccessful candidates. That's the only appeal. All other appeals are by the commission, state, and the successful candidates, which your lordships are hearing.
The unsuccessful candidates got a judgment in their favor.
Partially, Millard.
So they are on this side so far as the appeals are concerned.
But because
then how do you switch sides to?
Yes, but the unsuccessful candidates have filed an appeal against that portion of the order which says that only revaluation has to be ordered.
Alternative directions you are aggrieved by.
But I am not aggrieved. The writ appellant.
Writ appellant, you are pointing out to them. The writ appellant are on this side.
But in that particular writ appeal,
you are having a direction loss now.
But in writ appeal
Loss of
1470,
direction.
but there is only one writ appeal 1470, which is filed by the unsuccessful candidates. I appear only for the respondents in that. who are the successful candidates. So, my lord, I'll be sailing along with the learned seniors who had argued before me.
He will be filing appeal against the main judgment.
No, my lord, that's not.
So who is the appellant for the unsuccessful
My lord,
candidate?
appellant is Mr. Prasin, my lord, is on advocate on record.
Is no one
We are
for?
appealing. We are
Huh?
appealing. Item
Only item
119.
119.
Item 119.
Acha,
We have
item
filed cross
119.
appeal.
So you challenge what?
Insofar
The
as
alternative directions.
yes, my lord, it is impracticable, my lord, unworkable for revaluation, my lord. So my prayer is to set aside this election.
Entire exams to be
Acha,
cancelled.
you want half
But
of
there is
the
no-
operative part to go.
There is no clause of revaluation. Therefore, my lord, I have filed writ appeal insofar as
So you support the moderation part.
for reconduct of the examinations, my lord.
Acha, second part. Oh.
Then anyhow, that-
So why do you have to stand on your feet to answer to that? Because the appellants are already taking
Yes,
care of that.
Yes, my lord, that is what
We thought that it's an appeal and that is the right appeal which one writ petitioner has filed, stating that alternative directions do not match with the outcome. I mean, only one is tenable.
yes.
So that she will argue when the time comes.
Yes. But in response to that, my lord, I may be given the opportunity to argue that. My lord, I'm placing it before your lordship so that may it not.
Once he files an appeal, once he files an appeal, he is a successful candidate. But I have got an order either for revaluation or cancellation or setting aside of that particular result of him. Then Lord, he becomes the main aggrieved person. He files an appeal. Should he not make submission and should not he takes a chance Lord, to argue and re-argue again?
No, no.
No, there's no chance.
For the present, you do not have to anticipate what would fall from the council who has filed an appeal for unsuccessful candidate or writ petitioners.
Yes, my lord, that is exactly what I'm saying, my lord, because I cannot anticipate what will be argued.
So
I
all
will
of
argue
them
in
on this
response.
side, all of them on this side would be on the same footing so far as
Yes,
that
my
is
lord, we are on
concerned.
the same footing. But if there is any new point made by the council in the writ appeal in 119, I
When
may
the
be allowed
time
to-
comes, we'll see that. I mean, that is, the chain of thoughts get disturbed with this kind of.
I'm sorry, my lord, I thought we should inform the honorable
So
court that there's one more.
the better
person
part
left.
would be that if the one side has addressed all the issues, so many battery of lawyers, then each one need not stand up. I mean, for us, it is a matter of great constraint to ask anyone not to argue. But our goodness should not.
That's why, my lord, I also said if required at all at the end.
We are paid.
I mean, anyway.
Lord,
So you also want to.
Item 117, I am appearing, right, by an appeal. I'll not take much time, Lord, only I'll take.
Everybody says so. But yes, what else do you have to argue?
Lord, writ appeal number 10-1066 of 2025, item 117, I am appearing.
No, Mr. Amarendra, you just sum up whatever you wish to say the way Mr. Vishnuvardhan Reddy did it.
No,
I think
I'll not go even to that extent, Lord. I'll only to take few portions of the judgment, Lord, where I have argued and pointed out they were not answered. At page, Lord, 274 in writ appeal 1066.
274 is the copy of the judgment.
Yes, Lord. The paragraph number, Lord, 291.
You are in which writ appeal?
Writ appeal 1066, 1066 of 2020. 117, Lord, item.
117.
Yes, serial number 117 in the cause list.
1080 is the writ appeal number.
For the convenience, my lord, your worship may also, I'll refer the book, my lord, volume given by the Public Service Commission for the convenience. Say.
Please make your
Yes,
submission.
my lord, page number 274. My lord, in this, my lord, paragraph 291, my lord, the learned judge referred the council's name. Lord, Learned Counsel for the unofficial respondents relied upon the following judgments of the apex court with regard to maintainability, revaluation, and judicial review. There are 7 judgments, Lord, quoted on point with para numbers. Lord, the dealing is at 292, Lord. With regard to the maintainability, Learned Counsel for the unofficial respondents submit that having participated in the selection process, the candidates cannot challenge the notification as per the law laid down by the apex court in the above said judgments. Lord, this is with reference to my argument that from the date of issuance of notification from February 2024 to from the issuance of ranking list dated 30th 3 2025, no single writ petition filed challenging the process of recruitment, etc. That based on that, Lord, I argued the point that the writs are not maintainable because having participated in the selection process, they cannot contest the matter having after publishing the result when they are unsuccessful. And Lord, 3 judgments I cited on that point, Lord. Manish Kumar Shahi, Madan versus State of Bihar, Madan Lal and others, they were extracted in para 291, Lord. And the answer is that, Lord, answer to my points were at 292. But in the very same judgment, the apex court observed that where malafide, unfairness, and wrongdoing takes place, the court can interfere. I have not referred the point, requested the court to not appreciate my point, and also placed the relevant judgment with the relevant paras. Not, but they were not dealt with is my respectful submission on the point of maintainability. The other point, Lord, is that he further contended that the petitioners have not raised any legal ground regarding violation of any statutory rule and infringement of their fundamental rights in order to grant relief as prayed for. Moreover, the petitioners have not explained as to how they are prejudiced, securing less merit and would have been secured more merit and within the zone of consideration. In the absence of rules, request for revaluation cannot be permitted. Lord, on this point also regarding revaluation, I have cited 3 apex court judgments, Lord, on the point. Lord, none of them, Lord, though the learned judge, Lord, he was brought to the notice regarding revaluation, Lord, on 3 judgments, Lord. Dr. NTR University of Health Sciences versus Serra Trinath. These are all, Lord, in my present grounds, I have stated all these judgments with para numbers in the appeal filed by me. And Lord, Ran Vijay Singh and others versus State of UP and Pramod Kumar Srivastava, these 3 judgments were cited by me on the point that, Lord, there cannot be any revaluation, Lord, without there being any rule. Your Lordships are aware, Lord, on the point of revaluation, Lord, the Rule 39D of Telangana Public Service Rules, Lord, provides that there cannot be any revaluation. There is a rule and notification para 15.5, Lord, is clearly stipulated that the revaluation cannot be permitted. This is another point, Lord, and the answer is
only due to paucity of time, your entire contention seems to be that the contentions that were raised by you as regards maintainability, revaluation, the scope of judicial review, and the necessity of the successful candidates being made parties have not been rightly considered. They were simply brushed aside on the simple ground that mala fides and the allegations would suffice for the purpose of maintainability.
Yes, I got that. Para 293, Lord, learned judge cited my point, Lord, but 294, there was no discussion. I read this 294, 2-line. Para 294, learned judge said,
yes, where there is allegation of mala fide or unfairness.
Yes, Lord.
Or there is any allegation of any wrongdoing, writs are entertainable. According to you, that is without saying what that wrongdoing or what that mala fide or unfairness is.
With respect, my Lord, there is no consideration at all regarding the points raised by us before the learned single judge.
That is what we wanted to impress, that we have understood your contention.
Very well. Regarding the yes, my Lord, on the conclusion, last part. On the conclusion, my Lord, the entire, my Lord, the judgment rendered by framing 2 issues. One is regarding procedural aspects. Another is, my Lord, regarding revaluation. Regarding procedural aspects, my Lord, learned judge himself, my Lord, is not convinced, my Lord, to stay the recruitment in further stages. He only directed, my Lord, to revaluation, to revalue the, my Lord, the process of selection. Then, my lord, regarding revaluation, there is no procedure, no rule, etc. And, my lord, on the point framed by the learned judge, my lord, on the first point, he himself, my lord, has not granted any relief, is my respectful submission. And regarding public interest also, my lord, I have pleaded in the affidavit earlier, my lord, before the learned single judge. And after lapse of 14 years, my lord, this recruitment is taken place. So, my lord, these are my points.
With your lordship's kind permission, my lord.
Yes.
But my endeavor will be to show to your lordship, my lord,
Yes.
right from the initiation of recruitment war, my lord, notification 2 of 2024 till the date of publication of results is ultra vires, or one way or the other way it is illegal. Thus, how, my lord, I just begin my preface my submission and begin my Lord, if your lordships, my lord, are kind enough, kindly, my lord, go to volume 7 of the paper book. All right, my lord, kindly have a look at, my lord, volume 3, my lord. My lord, at page 408. At page 408, my lord, your lordships will find the judgment of a learned single judge, which was with reference to, my lord, notification number 4 of 2022. My lord, prior to the issuance of this notification for Group 1 services examination, there was a notification, my lord, with the number 4 of 2022. My lord, this was issued for filling up of Lord, 503 vacancies. A preliminary examination was held, and that preliminary examination was cancelled on the ground saying that there was a paper leakage. Lord, why I am trying to submit this to your Lordship, Lord, is this. The claim or elevation of the status than what it, in my humble submission, is that it is a constitutional body, every weight shall have to be given to every action taken by it. In my humble submission, belies by the very fact that in my written submissions I have said, my lord, how many examinations or how many notifications suffered, my lord, a setback, my lord, either before this court or, my lord, in their own hands. Going by, my lord, this particular notification, not by, for this particular examination of Group 1 services. But what happened is they have initially given a notification in 2022, numbered as, my lord, notification number 4 of 2022. Then a preliminary examination was conducted. My lord, then the PSC itself cancels it, saying that there was a paper leakage. Then, my lord, another preliminary examination was conducted. It became subject matter of challenge before this honorable court how this writ petition crops up. My lord, this is relevant for me for two reasons. Firstly, the PSC is not above the board. Secondly, my lord, in this writ petition, persons who filed the said writ petition, my lord, inserted a prayer saying that there shall be an answer book. There shall be an answer book which contains the full details of the candidates, like his name, his hall ticket number, his caste, everything is reflected in the answer sheet and the hall tickets. That was the prayer. In connection with that prayer, my lord, the respondents filed a counter affidavit saying that last 70 years we have never, and even the predecessor PSC of APPSC, we have never printed the details of the candidate on the answer scripts. The reason that they gave for varieties of reasons, administrative and convenience reasons. This is what they stated. So, my lord, my humble submission would be to start from here. First, my lord, the entire submissions, my lord, were moving around. The question was whether the issue of second hall ticket, allotment to centers, then, my lord, the answer sheet, its pro forma, etc., whether these are all valid or not, but the submissions made before your lordships, my lord, elaborately with some vehemence, my lord, or with erudition. My lord, to meet that only, I feel that, my lord, reference to this judgment is necessary. In this, my lord, result is this. They have changed in the instructions on the hall ticket with reference to need to undergo a biometry, what you call it as attendance or whatever it is called, but before they enter the examination hall or after they have entered the examination hall. My lord, the issue, my lord, that was raised before the court is the conditions in the notification, whatever we call them as conditions or, my lord, terms of the notification, are law unto themselves. They bind both the PSC and the candidates. If they bind the candidates, they equally bind the PSC. Therefore, you could not have changed even one criteria as respects even not taking the biometry of the candidates. That was the issue raised. But that issue was favorably decided in favor of the petitioners. A writ appeal was filed. Writ appeal was dismissed. An SLP was filed. In the SLP, when the SLP was pending, then, my lord, coolly this notification was given. My lord, the directions therein were to complete the, my lord, selection of the candidates in terms of the notification. That is notification number 4 of 2022. Why I was trying to submit, my lord, it is ultra vires. My lord, a direction of a court, a final order of a court, in my humble submission, shall have to be complied with. Any action taken, Lord, your lordship knows that line of judgments, my lord, DDA versus Skipper, etc., my lord. Those line of cases do suggest, saying that any action taken in violation of a court direction will be void. So it becomes void or ultra vires, whatever the illegal, whatever the language that we may use. I put it on the ground saying that this notification and whatever are the steps taken subsequently, they stand to be illegal or ultra vires. Is the submission? My lord, can your lordships kindly now go to, my lord, this decision it starts at page 410. Paragraph 6, my lord. Can I read?
Yes.
Learned senior counsel appearing for the petitioners has further placed upon the judgment of the Honorable Supreme Court in the case of State of Tamil Nadu and others versus G. Hemalata and others in support of his contention that the instructions issued by the Telangana State Public Service Commission and short commission are mandatory, having the force of law, and they have to be strictly complied with, and that the strict adherence to the terms and conditions of instruction is of paramount importance. He submitted that whenever the commission felt necessary to change the directions of the instructions, it would issue an addendum, corrigendum to the notification, as was done in respect of Group 4 Services Notification 19 of 2022, making certain modifications. A copy of the same is filed before this court along with a memo dated 12/7/2022. He submitted that no such addendum was issued in the case of Group 1 notification. Then, my lord, the learned advocate general, appearing for the respondent, relied upon the averments made in the counter affidavit and submitted that all the necessary steps have been taken to safeguard the conduct of the examination in free, fair, and transparent manner. This is always will be the contention of the PSC, that we are doing everything in fair, my lord, free, fair, and transparent manner. Lord, any doubt, my lord?
No, no. Yes.
My lord, free, fair, and transparent manner, he submitted that all necessary steps were taken to prevent any impersonation by the candidates. He has drawn the attention of this court to the averments in the counter affidavit, wherein the steps taken by the respondents have been enumerated in support of his contention. In respect of the omission of or deviation in case of one candidate, my lord, he submitted that the inquiries made, it is learned that the maiden name of the candidate was so and so, but since by the time of submission of her application she was married and therefore she has signed the photograph as Nandini by using her married surname. But in the examination hall, on the advice of the invigilator, she has signed as Y Nandini. A copy of her marriage certificate that may not be necessary. He kindly come to the next page. Petitioners have not point. He submitted that the instructions on the notification are for the candidates to follow for successful holding of the examination in a free and fair manner, and they cannot be challenged by the candidates on non-compliance of only one instruction by the respondent, and that such non-compliance will not invalidate the entire examination. He further submitted that respondent would adhere to or follow the directions of the court in the forthcoming examination so adjourned. With regard to the judgment relied upon by the learned senior counsel, the learned advocate general submitted that it is distinguishable on facts. It is submitted that in the said case, it is the candidate who did not follow the instructions of the commission and not vice versa, and therefore the said judgment is not applicable to the facts of the case before this court. Having regard to the rival contentions and the material on record, this court finds that the respondent has issued notification, and one of the instructions to the candidates in the said notification is to appear in the examination center 30 minutes in advance in order to enable recording of biometry. Having given the instructions, the respondent was required to follow its own instructions, and in the examination held in the first instance, that is on 16/10/2022, it did follow the instructions. However, respondent did not follow the said instructions in the examination held on 11/6/2023. The said instruction did not find place in the hall ticket and was thus not followed on the day of re-examination. The case of the petitioner is that the respondent has not cancelled the notification but has only cancelled the examination and has issued hall tickets for the examination held on 11/6/2023 pursuant to the notification dated 26/4/2022, and therefore instructions given in the subject notification have to be followed even for the examination held on 11/6/2023. It is also brought to the notice of this court that in the case of Group 4 examination, when the commission intended to change the above condition, it issued addendum, but no such addendum was issued by the commission in respect of Group 1 examination. Learned senior counsel for the petitioner submitted that due to non-compliance of the instructions given by the respondent itself, the examination has to be set aside. Then, my lord, the respondent in its counter affidavit kindly omit that portion. Then kindly come to, my lord, paragraph 12 onwards, my lord, my lord, the learned judges versions, my lord. Then kindly go to paragraph 13. Can I read?
Yes.
Honorable Supreme Court in the case of State of Tamil Nadu versus Hemalata has held that the instructions issued by the commissioner are mandatory in respect of the candidates appearing for the examination and thus have the force of law and have to be complied with strictly. It was held that strict adherence to the terms and conditions of the instructions is paramount. It was held that High Court in exercise of powers under 226 cannot modify the instructions issued by the commission. From the above, it is noticed that compliance with the instructions issued by the commission are both directory and mandatory for both commission as well as the candidates, and the commission was entitled to change the instructions if it chooses to do so, but if it intended to change the instructions, it could have done so by issuing an addendum as was done in the case of Group 4 examination. Having failed to do so, it has to follow instructions mandatorily. The contention of the learned counsel for the respondent that prelims is only a screening test and that even if certain candidates could get through due to alleged deficiencies, laxities in the conduct of examination, they would have to face the main examination is also not acceptable for the reason that all the successful candidates in the prelims would not be allowed for the main examination, but would be allowed in the ratio of 1:50 in the order of merit in the preliminary examination. This may result in some of the meritorious candidates being excluded from mains examination. It is noticed that large number of the candidates have appeared for the preliminary examination held on 11/6/2023 and are preparing for the main examination, which would be deciding examination for the aspirant. Therefore, to prevent any injustice being caused to them, this court is inclined to cancel the Group 1 preliminary examination conducted on 11/6/2023 and to direct the respondents to kindly, this portion which I was trying to direct the respondents to reconduct the preliminary examination by implementing all the general instructions issued in the notification, including biometric, without any exception. This court would fail it in its duty if it does not express the displeasure about the way respondent has filed counter affidavit without taking care to verify the details of the candidates who appeared for the examination. The web notice dated 28/6/2023, wherein it is mentioned that the number of candidates who have appeared in the examination as against earlier report dated so. But in the counter affidavit, which is filed on so and so, it is mentioned as 2,33,248. That is around 200 and odd less number of candidates appeared for them. Thus, the respondent does not appear to be careful either in conducting the examination or correlating the data of the candidates who appeared in the examination for Group 1 services in spite of its importance and its impact on the candidates appearing for restrictions are accordingly allowed. My lord, therefore, my lord, the directions which your lordships have seen in the earlier page, my lord, that respondents are direct and to direct the respondents to reconduct the preliminary examination by implementing all the general instructions and issued in the notification, including biometric, without any exception. This code would that is the direction issued. My lord, in the teeth of this direction, in my humble submission, it was not open for them to not to proceed with this. And my lord, this judgment, Lord, was carried in appeal. My lord, confirmed in the appeal. I'll just try to take that. Before I take to that, my lord, may I just can I just take your lordships to paragraph 11? There, one of the prayers was to make an answer sheet available with all the details of the candidates. Then the Mullah, the PSC opposed it. Your lordships will kindly have a look at paragraph 11. Lord, entire things, Lord, goes around this, whether what they have contended there, what they have now done is whether mutually contradictory or not. Can I read, my lord?
Yes.
It is submitted regarding the contention of the petitioners that the commission has not supplied pre-printed OMR with hall ticket number and photo. As such, there are chances of manipulation. It is submitted that since the inception of TSPSC, pre-printed oblique name-based, photo-based OMRs were never supplied in any examination. The OMR sheets shall be recognized with its unique barcode and it will be matched with the hall ticket, bubbled hall ticket number and question booklet number filled in by the candidates themselves, leaving no scope for the manual intervention in evaluation of the OMR sheets. The candidate writes his name in capital letters and affixes his signature at the bottom of the OMR sheet. Similarly, the invigilator affixes his signature after establishing the identity of the candidate thoroughly. This is the standard practice. Lord, I may humbly submit what they have stated. This is the standard practice. This is the standard practice which is time tested and followed, given by the UPSC, even by the UPSC. Printing of hall ticket details on the OMR sheets has its own limitations in terms of the confusion that may arise in the venue on account of varied reasons. Even one incident of handing over absentees OMR to the next person would have cascading effect in the entire examination room. Considering these kinds of possibilities and other logistic issues, the blank OMR sheets are given to the candidates with instructions to fill their hall ticket numbers. Filling up of hall ticket number by the candidates themselves would ensure that there is no confusion in the exam hall just before the examination. This is the stand that they have taken, saying that pre-printing of the details of the candidates are and giving all other details which they are not the standard practices. They are not the practices of the UPSC. Therefore, to say that that should be issued is wrong is what they have said. Now what we are now contending, Lord, is what we are contending here is this is all a pre-planned one. There they have taken a stand, Lord. Just Lord, this decision was on in 2023, Lord, September. February is the notification. 19 to 2024 is the notification. There is something, my lord, on the dark side, which I may not be, maybe that I will not be able to, because I am not the custodian of the record. What is transpiring inside, I may not be able to fully explain. But still, I can submit to your lordship saying that something transpired after this. They take a firm stand, saying that this is the standard practice, this is how we do, this is how the entire country does. Not that. A comment was made on the learned judge, saying that the learned judge has termed UPS as a superior body. Right? He did not put it as an appellate body. He only said that UPS is slightly superior in the sense that, language at times not maybe. But to say that the learned judge was wrong, saying that he has taken UPSS and he proceeded on a wrong footing, saying that these are not the methods followed by a superior body, therefore you can't follow this method, is not, in my humble submission, is not a correct version. They were not, my lord, in my humble submission. They were not, I don't know what I should say, but they should have been fair to the learned judge while making that submission, is what all I can submit. But this is the stand that they have taken. If your lordship will go 1 second, I'll just take your lordship to the appellate order. It is there in volume 7. Your lordship kindly just.
We have, is it necessary to go to the appellate order? We have taken that point.
Your lordship have taken. I will not. I will not. I will go by your lordship. Since all that I was trying to say is appellate order confirms this order. Then, Lord, an SLP was filed. I'll just give the SLP number with your lordship's kind permission. My lord, if your lordships have got the index of this, my lord, in the first volume itself, your lordships have got the index, my lord. At the last page of the index in volume 7, your lordships will find SLP civil diary number 19 to 2024.
Serial 52. Serial 52.
Yes, entry 52, my lord. What I try to humbly submit, my lord, is they file an SLP there on the same day. They feel that, my lord, they are aggrieved by the order of the learned single judge. They file an SLP before the Honorable Supreme Court. They have got the audacity of issuing a fresh notification, my lord, on the very same day, my lord, on 19 to 2020.
Yes.
Lord, before I go to the next controversy, can I just request your lordships to have a look at, my lord, page 1375, a GO issued by the government.
Yes.
Page 1375. My lord, according to me, PSC by itself has no power to either issue a notification on by itself. I try to make myself clear, my lord. PSC is a recruiting agency. My lord, it has to issue notification on the government, my lord, intimating or informing the vacancies which have to be notified. Same way, my lord, for the purpose of cancellation also, it is the government, my lord, which has to initiate the process of cancellation or withdrawal of the notified vacancies. In the absence of that, question would be whether the PSC will be entitled to cancel the earlier notification in the teeth of the single judge's order, division bench order, and the Honorable Supreme Court's order. Will your lordships kindly permit me to read this? GO 16. Can I read, my lord?
Yes.
My lord, paragraph 2 says, my lord, there are 60 vacancies in various categories under Group 1 services as shown in the appendix to this order. And they shall have to be filled through Telangana Service Commission. The Telangana State Public Service Commission shall take necessary steps to direct steps for direct recruitment to the vacant post permitted to be filled up in this order. I may just submit what they have done, my lord, is they are now saying that there are 60 vacancies in different departments having different, my lord, post code numbers. They are saying that please fill up these, or now, my lord, they they require, or my lord, they request the Public Service Commission to fill up these 60 vacancies. In my humble submission, this is not a blanket, my lord, power or, my lord, mandate or whatever requirement that was made by the state government to conduct or, my lord, to issue a fresh notification cancelling the earlier notification. This is impermissible. This is where I was trying to say is beyond the power of the Public Service Commission. Kindly, just for my satisfaction, also have a look at paragraph 5. The concerned officers were directed to furnish the details of vacant posts permitted to be filled up in this order. That is about those 60 posts. To the State Public Service. And paragraph 6 also says that if some of the posts are earlier, my lord, taken out of the purview of the PSC, they may be again brought into the purview of the PSC. That is what paragraph 6 says. Kindly see the date of the order is 3rd February 2024. Now, my lord, with this in background, kindly now have a look at, my lord, the notification. At page 358.
Page 3.
358. Volume 1 page.
Which notification?
Volume 3, your lordships.
So that is also at page 1378.
Yes. Yes.
In the same volume where you are referring to page 1375.
Yes. Yes, sir. Your lordship. Yes.
तो फैन पेज करिए थोड़ा कर्टन भी हटा दीजिए सेकंड हाफ में गर्मी होने लगती है
1 second, Lord, before.
कोई स्पेसिफिक इंस्ट्रक्शन नहीं दिया है
Well, I'll be. But this notification was issued. Before issuing this notification,
Yes.
before issuing this notification, my lord, PSC said that we have held a meeting of ourselves. We have deliberated, and because of some two GOs issued, we are now GOs are not those which directed the PSC to cancel and issue a fresh notification including these 60 vacancies. My lord, PSC, my lord, claims that they have deliberated among themselves, that maybe members have sat and they have deliberated among themselves and they have decided to issue the notification. My lord, in my humble submission, this course is not open to them. They issue this notification. Kindly now.
Yes.
That portion I am just. Will your lordships kindly permit me to take your lordships to page 113 of my compilation, Lord, along with the written argument.
Page
Written
number?
argument submitted by me, Lord.
Page number?
113, Lord.
113.
Yes. Written argument submitted by me, Lord.
Yes.
Commission has deliberated in detail about the various issues concerning the notification number 4 of 2022 dated 26/4/2022 for Group 1 services. Having taken totality of the circumstances into account, the Commission has decided to cancel notification number 4 of 2022 issued on 26/4/2022 for 503 vacancies in public interest. In accordance with the decision of the Commission, the above notification is hereby cancelled. Pausing for a minute here, thinking aloud for myself, my lord. Question is whether such a course, unless, my lord, some authority is bestowed, or, my lord, just now, my lord, as read by my Leonard, one of the Leonard senior and erudite advocates, my lord, my Leonard friend Mr. Shankar Narayana, he has taken your lordships to Articles 3152, 320. My lord, I have just now gone through. If necessary, I may go through those provisions. My lord, those provisions do not, my lord, clothe PSC with such power, nor do the procedural rules or not the regulations. Not, this is the decision taken. Not with here itself, not I may just take your lordships to whether such a course is open to them or not can be looked into, not from their own regulations which they have filed. Along with the government's regarding government written arguments, at page 217, my lord, they have enclosed regulations. My lord, your lordship knows regulations normally deal with, my lord, the matters which can be dealt with by the commission. Not these, not these are issued under or in exercise of the powers under 318. Will you lot? That is about the powers of the commission with reference the as to conditions of service of members and staff. Not these regulations do not deal with notifications, etc. Ultimately, we may have to not insofar as notifications are not their duty to conduct, I may call it as duty, not power. Duty to conduct the examinations is traceable to 320, Article 320 and Clause 3. But 320 as such, Lord doesn't give it power to frame regulations to this effect. They may, Lord, give power to a limited extent. Lord, now kindly have a look at Lord Article 320 also. Lord, proviso to Lord Article 320, Clause 3. There is a power to make regulations. Can I just take? I'll directly take your losses to the proviso. Provided that the President as respects the All India services and also as respects other services and posts in connection with the affairs of the Union, and the Governor as respects other services and posts in connection with the affairs of the state, make regulations specifying the matters in which either generally or in particular class of cases or in any particular circumstances, it shall not be necessary for a public service commission to be constituted. That's all. If there are any regulations framed, they will be within this framework. Therefore, regulations, in my humble submission, do not speak about the powers which can be exercised by the PSC. If at all there are any powers. Article 320 only says it is the duty of the commission. It doesn't say it is the power of the commission. In my humble submission, there is no power to make rules under either 315 to 320. There is no power to make rules. Assuming that, my lord, rules can be made in the form of executive instructions.
Yes.
They only continue to be in the form of executive instructions only, but they do not have the statutory flavor. Kindly have a look at, my lord, page 244 of the written submissions of the government where they have enclosed the rules.
Page.
Page 244 of the government's written submissions, my lord.
Yes.
these rules, my lord, subject to correction by the learned advocates appearing on the other side, do not also clothe the commission with the power of, my lord, cancelling a notification. It may be that, my lord, if your lordship just have a look at the look at 244, though they called it as, my lord, adaptation under 101. My lord, adaptation of an executive instruction. My lord, if it was a, if it has a statutory flavor, it comes as adopted as a statutory instrument. If it was an executive instruction, my lord, it will be adopted as in the form of an executive instruction only. There must be power to frame the rules. The Telangana State Public Service Commission hereby makes the following rules regulating its procedures in relation to performance of its functions in supersession of the rules applicable under section 101 of the Andhra Pradesh States Reorganization Act.
Yes.
My lord, I have just gone through, my lord, I did not find any provision, my lord, which empowered them to act as they have acted. Then, my lord, broadly,
Yes.
in our writ petitions, my lord, we have stated saying that the act, my lord, I'll just narrate. Everything is a concerted, deceptive, design, and manipulative effort that has gone into the selections, is the submission. If it was so, my lord, whether these selections can be sustained. The argument, my lord, your lordship, my lord, many learned counsel have argued with authenticity of very many judgments, my lord, principles of which, my lord, your lordships are thorough with. To say that there is, the allegations are insufficient to come to a conclusion of either cancellation of an examination or cancellation of the entire selection process. That is the endeavor which they were trying to make. I call many of the judgments which have proceeded, either proceeded on the facts of those cases, or some of them are abstract propositions, I may say. But ultimately, if I could satisfy your lordships, my lord, by showing different my lord, documents which are filed before your lordships, that there is a concerted effort to achieve the result which they have achieved, then, my lord, perhaps I am entitled to succeed, despite, my lord, plethora of case law which is cited before your lordships. If I am, if I fail in my duty to, my lord, in my effort to succeed, saying that, my lord, there is, the material is sufficient, maybe I'll fail. But now, from there, what I try to submit, my lord, is this is how the notification was issued. Then, my lord, they have conducted a preliminary examination in June. My lord, figures are meticulously given by, my lord, the learned senior advocate, Mr. Shankar Narayana. He has furnished meticulously what is the total number of candidates who have applied, appeared in the preliminary examination, who qualified, etc. were given. My lord, I don't need not repeat. My lord, around 33,000 candidates have been have cleared the prelims for being, my lord, allowed to, my lord, the main examination. Then, my lord, they kept silent for some days. Then they, what they say is, on 16/8/2024, we have given a web note or, my lord, an information on the online. I am very poor in the language of that Lord, information technology or whatever we call it. Lord, I do not know anything about it except Lord, a green button and a red button. Therefore, I will not be able to correctly communicate to your Lordship. With Bhagan. But what I try to humbly submit, they have put up something on the web note on 16/8/2024 saying that we have placed the answer book on the website. Please look into that. Is what they have stated. They have, in my humble submission, not clearly stated in those in that particular communication saying that we have now changed the method of examination or method of issuing. We are going to issue fresh hall tickets. We have changed the method of examination or method of evaluation, etc. Earlier, whatever that was there, we are intending to change it now. Is not the one which is even. On the other hand, the notification itself, my lord, makes it clear that whatever they wanted to provide in the notification, that is selection procedure by way of a preliminary examination of what type, or if there would be a change, what change it would be. Then, my lord, what type of main examination will be, etc. My lord, was already given. So all the care was taken, my lord, in the notification itself. And what if they want to go for a change, what they would change also is given, including, my lord, normalization, scaling. My lord, much argument went on about that scaling, normalization, moderation, etc. They said if we want to go for a normalization, this will be the formula. And they have not spoken to about moderation. They have not spoken to about, my lord, the double valuation, etc. If the notification was clear, question is introduction of double valuation. And introduction of double valuation and introduction of that particular answer sheet itself will stand the scrutiny of law. My humble submission would be that, my lord, this is all, my lord, an afterthought, changing it for the purpose of benefiting some few individuals. And we have filed, my lord, in my writ petition, I have with, my lord, the mathematical data or, my lord, graphic data, I have given how results were manipulated. But this manipulations, my lord, your lordship, sir, I may humbly submit to, my lord, say or prove that through all these manipulations will not be. Ultimately, I can say this is what has happened. What can be, my lord, what follows from what has happened or what is on record, it follows. I can only say, not this is on record. This is how it went on. Now, my lord, I will now take your lordship to, my lord, the notification. How meticulous they were. My lord, will your lordships kindly go to, my lord, page 371. It starts at 358.
Of your note,
No, my lord, this book 1.
which volume?
1066, book 1, my lord.
No, which part? Which?
Appeal, my lord.
No. There are matter volume 3. 3. Yes.
My lord, paragraph 9
Page.
at page 371. Can I read?
Yes.
Scheme of examination for preliminary test and main examination is prescribed as per GOMS number 55, General Administration dated 25/4/2022, and as amended by GOMS number 29, General Administration dated 8/2/2024. Syllabus for the main examination has been shown in Annexure 2. Then, my lord, kindly come to 10.5. Sorry, centers for the preliminary examination 10.1. Kindly omit that. Then below 10.5. Written examination main will be held at Hyderabad, including HMDA jurisdiction or any other district centers as mentioned herein. Then, my lord, kindly go to paragraph 12.
Paragraph.
12, my lord, at the bottom of 372. 12A says there will be a preliminary test objective type comprising of general studies, mental ability. This test is meant for shortlisting the number of candidates eh, to be admitted to main examination. The preliminary test will be conducted in English, Telugu and Urdu. Then, my lord, kindly omit. Go to C, my lord. The main examination will be conducted in English, Telugu and Urdu. The papers except general English in the main examination shall be answered in English or Telugu or Urdu only as chosen by the candidate. A candidate is not permitted to write part of the paper in English and part of the paper in Telugu or Urdu. Paper in general English is a qualifying one and the standard of this paper is that of secondary school certificate. Minimum qualifying marks should not be so and so. Kindly omit that. Then, my lord, kindly come to page 374. Once medium is chosen, 12.4 I am reading them. The candidate has to write the answers in the medium chosen by him or her only. If there is any deviation from paper to paper or part of the paper, candidature would become invalid. Then, in respect of evaluation of the mains examination, answer scripts, main examination answer scripts, the commission will resort to digital valuation mode or conventional mode. But they have opted for only two modes: digital evaluation mode or, my lord, conventional mode, depending upon the administrative and operational convenience. They may, that is, one of the two only will be chosen. It will be, the choosing will be depending upon the operational and administrative convenience. They cannot, they have not reserved in themselves to go for another method. My lord, similarly, my lord, about preliminary test also, they have stated saying that it will be in two types. Huh? ఏముంది? Hmm. 372 నా? ఇది కాదు. My lord, may I just take your lordship's to in the instructions at page annexure 7 at page 407. Can I take? The Telangana Public Service Commission has been using computer-based recruitment test for various recruitments from 2017 onwards. The CBRT involves the normalization of the scores of the candidates for the examination which are conducted in multi-sessions to take into account any variation in the difficulty levels of the question papers across different sessions. Further, the process of normalization as adopted by major leading organizations at national and state level in the conduct of recruitment examination and entrance examination is also adopted by the Commission. Commission has adopted the following formula to calculate final score of candidates in the multi-session CBRT examination as mentioned by the experts committee constituted by the Commission. What I was trying to submit to your lordship, wherever they wanted to provide for, what type of examination they would resort to, what type of evaluation they would resort to, etc. That was made very clear in the notification itself. Question is whether later change is a manipulation or intended for some ulterior motive or object. That will, I'll continue tomorrow.
Just record the names of. Yes, are there some mentions from the
Your
remaining
Lordships,
list?
kindly item number 123, you Lordships. Item number 123, you Lordships list.
Yes.
There is an urgency in this matter, you Lordships. Contents will be listing before the Honorable Tribunal on 10th. You Lordships may kindly accommodate me next week, or if you Lordships are not taking up this matter tomorrow or Monday, you Lordships, as per you Lordships convenience.
When is the contempt?
10th January, you Lordships.
Give a date in first week of January.
No, item
I'm
138, I'm
obliged.
party in person in the case. Item 138, I'm appearing party in person in the case, Your Honor. Pleadings are completed. It was for final hearing, granted the date of today, about a month back. I'd request if it can be taken up tomorrow at Your Honor's convenience. I'll be grateful.
On next Wednesday.
My lords,
Your
item
Lordship's
139.
kind permission.
My next.
139, my lords.
Obliged, Your Honor.
139 may be taken up next week, my lords.
My lord,
Have
135,
respondent in item number
136,
139, my lords.
135, 136, my lord. There is a stay of the dismissal order that was set aside by the tribunal. My lords, the matter has come on mention, my lord. It was on the last occasion, other side took time.
Continue on next Tuesday. Tomorrow, is it possible? Next Tuesday?
My lords,
Your
I am
lordships kind-
respondent in item number 139, my lords. Might be taken after vacation, my lords. There is an interim order in favor of petitioner.
I am for petitioner, my lord. Pleadings are completed. It pertains to forest rights of scheduled tribe people, my lords. It was posted for final hearing. Twice it didn't reach. Your lordship
It's a matter of
posted it to
2025,
today.
my lords. Challenging
20
section 20 of the Telangana Forest Act, wherein
24.
an
My
interim
friend,
order is
let my
there in
friend
favor
not
of
argue
petitioner.
now. Your lordships may take it up next week. Let him argue at that time, my lords, not at this time.
Next week, you are not there.
My lords, additional AG is taking up this matter, my lords. Additional AG is taking up this matter. In fact, he requested it to be posted after vacation, my lords.
Let it come
Yeah.
after vacation.
Your lordship,
After vacation.
kind information, my lord,
Kindly
the
oblige.
transport matter, my lord, which is at item 140 and 41, my lord.
Yesterday
Your
also it was there, perhaps, no?
No, last week it was there, my
Oh,
lord.
last
Today
week.
morning I made a mention for 2:15, my lord. I request your lordship, it will not take much time, my lord. Tomorrow, anytime convenient, my lord. For the reason, the interim order